Imagine being thrown into a courtroom, not for a violent crime, not for fraud, but for a parking violation. Now imagine that courtroom is run by a man who sees the color of your skin before he sees the facts of your case. This is the story of Danielle Brooks, a mother, a nurse, and an ordinary citizen who parked her car just a few inches outside the lines, and nearly lost 10 years of her life for it. But what began as a quiet injustice sparked a storm of truth, courage, and accountability that no one saw coming. The sun in Macon Ridge, Georgia, beat down on the asphalt like a punishment. It was the kind of heat that made the air shimmer, made your skin feel like it was being pressed by an invisible hand. On this Wednesday afternoon in late June, the sidewalks were empty, and the courthouse square was mostly silent except for the hum of cicadas and the low grumble of tired engines trying to stay alive in the thick, southern air. Danielle Brooks, 34 years old, was used to this heat. She was used to a lot of things: overtime shifts at St. Agnes Community Hospital, balancing groceries with a toddler on one hip and a 7-year-old asking too many questions, and juggling bills that always seemed to show up early. What she wasn't used to was trouble. She had never been arrested, never raised her voice in public, never even jaywalked unless no one was around. Danielle lived carefully. She didn't have the luxury not to. So when she pulled into the courthouse parking lot that afternoon, she was exhausted but alert. Her shift had run long. A patient coded twice on her. Then she had to cover for another nurse who didn't show. 12 hours in a building where people bled, cried, begged, and sometimes died, it took a toll. Her scrubs were wrinkled. Her sneakers were a year past needing replacement. But her mind was sharp, and her only mission was to file the last paperwork related to her late mother's estate. That was it. 10 minutes tops. There were no open visitor spaces. Not one. The lot was small, the lines faded. So when she spotted an empty space near the far end, she didn't think twice. She backed in, straightened the wheel, and didn't notice that one tire was 2 inches over a faded yellow stencil on the pavement reserved for county officials. 10 minutes later, paperwork stamped and tucked safely in her shoulder bag, Danielle returned to her car and saw a man in a tan uniform standing next to it, arms folded. His aviator sunglasses reflected her approaching figure like a mirror. His name tag read Sheriff H. Dean. "You the owner of this vehicle?" he asked, not moving. "Yes, sir. I just..." "You parked in a restricted space. That's a violation of County Code 47-19B. Danielle stopped in her tracks. "I'm sorry, I didn't see any sign. I was only inside for..." He raised a hand. "Intent doesn't matter, ma'am. You're parked illegally in a county-designated space." She tried to keep her voice calm. "I didn't know. If there's a fine, I'll pay it. I didn't mean. I'm going to need to see your ID." It happened so fast, she didn't know whether it was real. One moment she was opening her bag, the next she was being asked to put her hands behind her back. "For your own safety," Sheriff Dean said. He placed cold steel cuffs on her wrists while courthouse staff and passers-by started to slow their steps. Danielle's mouth went dry. "This isn't right. I didn't do anything criminal." "You resisted instructions and attempted to argue," he replied flatly. "You're being charged with criminal trespass and obstruction of a county officer." "Let's go." Word spread fast. Macon Ridge was the kind of town where people still read the paper, where courtroom drama was as much entertainment as it was news. Within hours, a local tabloid blog ran the headline: "Nurse arrested for defying county law claims it's just a parking spot." It wasn't just a parking spot anymore. It was now a criminal case. And it had landed in the courtroom of Judge Clayton Reeve, a man whose name echoed through the black community like an old warning. Judge Reeve had worn his robe for 22 years. Appointed during the Bush administration, he came from a long line of Georgia lawyers and had a reputation that felt carved out of stone: unmoving, severe, and famously unmerciful. A man with no tolerance for attitude in his courtroom, Reeve had sentenced a teenage boy to 5 years in juvenile detention for shoplifting sneakers. He once referred to a black defendant as uncivilized in open court and still kept his seat. And now Danielle was standing before him in an orange jumpsuit, trying to understand how a parking violation had turned into her facing 10 years in prison. The district attorney, Tom Wilkes, a clean-cut politician with eyes on a future congressional seat, filed formal charges within 48 hours. Criminal trespass, failure to comply with a peace officer, and, shockingly, a third charge, interference with governmental operation. "They're trying to make an example out of her," whispered one courthouse clerk. But for what? Danielle had never felt more alone. Her public defender was underpaid, overworked, and seemed uninterested. Her arraignment was scheduled in 5 days, and by then, local activists had caught wind of the case. A retired lawyer from Atlanta named Amira Caldwell, black, sharp, and relentless, reached out to Danielle's sister after seeing the case online. Amira had seen cases like this before. Too many. Black defendants overcharged for minor infractions. She'd fought to overturn 3 wrongful convictions in the past 5 years, and her name carried weight in progressive legal circles. She visited Danielle at the county jail and really listened to her side of the story. Danielle, hands trembling, said quietly, "I don't even know how this is happening. I parked for 10 minutes. And now they're calling me a criminal." Amira nodded. "They know what they're doing. But they picked the wrong woman this time." Outside the jailhouse, a small crowd had begun to form. Signs reading "Justice for Danielle, overcharged equals oppression," and "We see you, Judge Reeve" began appearing in front of the courthouse. Local news stations picked up the story. A community group organized a fundraiser for Danielle's legal defense. On Twitter, a video of her arrest, taken by a courthouse staffer from an upstairs window, went viral. Over 2.7 million views in 2 days. People weren't just angry, they were stunned. "I've seen people get a warning for parking like that," one user posted. "This woman gets 10 years? What country is this?" But behind the viral outrage, Judge Reeve was unmoved. He issued a statement to the press. "The court does not concern itself with internet gossip. The charges stand as filed. Let the law do its work." In private, he told a clerk, "I'm going to teach that woman some respect." The courtroom smelled like polish and sweat. It was Monday morning, and the first official day of the case that had started from a parking mistake and escalated into a national controversy. In the front row sat reporters from Atlanta, New York, and even Los Angeles, their notebooks poised, their cameras tucked into bags under benches. Outside, protesters had already gathered, some with bullhorns, others with homemade signs taped to cardboard. "This isn't justice," and "a parking spot shouldn't cost a life" were among the slogans being chanted across the street. Inside, Judge Clayton Reeve took his seat, robes stiff on his shoulders. He looked down over the bench with his usual indifference, but those who knew him well could see it. He didn't like being the center of attention for the wrong reason. He glanced toward the defense table. Danielle Brooks sat beside her new attorney, Amira Caldwell, dressed in a navy blazer, her hair pulled back, face calm but unreadable. Danielle wore the only outfit she had left that wasn't taken during booking, a plain blouse, slacks, and borrowed shoes. She didn't say much. Her voice had shrunk in the days since her arrest, replaced by silence and the dull ache of disbelief. Across from them sat District Attorney Tom Wilkes, flanked by 2 junior prosecutors and a laptop that never seemed to close. He leaned over his notes, polishing every word for the performance ahead. This wasn't just a case for him anymore. It was a stage, and the country was watching. "Court is now in session," the bailiff announced. Judge Reeve wasted no time. "State of Georgia versus Danielle Brooks," he read, glancing briefly at the file before him. "Charged with criminal trespass on government property, obstruction of a peace officer, and interference with governmental operations." Amira stood slowly. Her voice was calm but cut like a blade. "Your Honor, the defense requests the immediate dismissal of all charges on the grounds of disproportionate application of the law and abuse of judicial discretion." Reeve raised an eyebrow. "You're welcome to file paperwork. This is an arraignment." "We've filed it, Your Honor. And more importantly, the charges themselves do not merit a felony hearing. This is a parking error, not a conspiracy." Wilkes shot to his feet. "Your Honor, the defendant refused to vacate restricted county property and demonstrated hostility toward a sheriff's officer. She asked questions, Amira interrupted. That's not a felony. Judge Reeve banged his gavel once. Enough. You can make your case during the hearing. The court denies the motion to dismiss. Trial will proceed. A quiet gasp rippled through the gallery. Danielle's jaw tightened, but Amira gently placed a hand on her arm. It's just beginning, she whispered. Outside the courtroom. By the time the hearing ended, hashtags were trending nationwide. Hashtag justice for Danielle. Hashtag parking while black. Hashtag Judge Reeve resign. Cable news networks ran opinion pieces. Talk radio exploded. Civil rights organizations took notice. The ACLU filed a motion to observe the trial. NAACP representatives reached out to Amira, offering research and historical context that could be used in court. Former federal judges condemned the case on live TV. But within the bubble of Macon Ridge, pressure only made Reeve more rigid. He doubled courthouse security. He denied all motions to release Danielle on bail. Flight risk, he said, despite the fact that Danielle had lived in the same house for 9 years and never left the state. Amira, however, wasn't backing down. She spent every evening in the public library's law section and every morning questioning courthouse staff, hunting for inconsistencies in the charges and background on the arresting officer. And then she found it. The pattern. Sheriff Harold Dean had a record, not criminal, but concerning. In the past 5 years, nearly 73% of his citations for misdemeanor violations had been issued to black residents, even though Macon Ridge was only 38% black. The majority of those citations occurred in the downtown district near county buildings. Parking violations, noise complaints, loitering, all subjective, all charged with intensity when the defendant was black. Amira smiled for the first time in days. This isn't just a bad arrest, she told Danielle in the visitation room. It's a pattern. And we're going to show the court that you're not the exception. You're the target. Danielle stared at her. But what if they don't care? Amira looked her straight in the eyes. They don't have to care. The jury will. Jury selection begins. 2 weeks later, the courtroom was once again full. This time, for jury selection. Judge Reeve had tried to keep the list small. But Amira exercised every right she had. She questioned every potential juror, noting biases, Facebook posts, church affiliations, even traffic records. Wilkes tried to fight her, but Reeve allowed it. Perhaps even he was starting to feel the heat. By the end of the week, 12 jurors were seated. 3 black women. 2 black men. 4 white women. 3 white men. It wasn't perfect, but it wasn't hopeless either. Amira stood for her opening statement on a Monday morning. She didn't shout. She didn't pound the table. She simply spoke as if she were telling a story to a friend. Ladies and gentlemen of the jury, she began, this case is not about laws being broken. It's about how they're applied. It's about how a system built to protect us can be used to crush the quietest among us. My client, Danielle Brooks, made a mistake. She parked in the wrong space. She should have received a fine, maybe a warning. Instead, she was handcuffed, jailed, and thrown into the machinery of a legal system that has historically punished black Americans for being visible. She paused, then looked each juror in the eye. This trial is not about parking. It's about power. And what happens when that power goes unchecked? The first witness was Sheriff Harold Dean. He walked to the stand with the stiff pride of a man who believed he was still in control. His boots thudded heavily against the wooden floor, and when he raised his right hand to be sworn in, he barely looked at the jurors. He adjusted his belt, cleared his throat, and sat upright, prepared to deliver a version of events he'd already told to reporters, internal affairs, and the DA's office. District Attorney Tom Wilkes stood confidently. Sheriff Dean, walk us through what happened on the afternoon of June 14th. Dean began smoothly. At approximately 3:10 p.m., I was exiting the south side of the county building when I observed a vehicle, make and model, 2010 Toyota Corolla parked in a space reserved for county use. It was clearly over the line. This wasn't a matter of inches. The front tire was well into the restricted zone. Wilkes nodded, as if the measurement was a confession. And what did you do then? I waited. I wanted to give the driver a chance to return. Approximately 10 minutes later, the defendant approached. I asked if the vehicle was hers. She said yes. I informed her that she had violated a county ordinance. And how did she respond? Dean's jaw tensed. She became defensive. Said it was just a spot. Said she was in a hurry. She refused to comply with instructions. Raised her voice. At that point, I made the judgment call to place her under arrest. Wilkes turned to the jury. Thank you, Sheriff. No further questions. Amira stood up slowly. Calm. Precise. Sheriff Dean, she began, are you familiar with County Ordinance 47-19B? Yes, ma'am. Can you read the last line of that ordinance aloud for the court? Dean leaned forward as a clerk handed him a printed copy. His voice faltered just a touch as he read. Offenders of this regulation shall be subject to a warning or civil fine not exceeding $100 unless the vehicle is found to be intentionally obstructing official business. Thank you, Amira said. Now, did my client, Danielle Brooks, at any point prevent your vehicle, or any county vehicle, from moving? No. Did she block any exit? Any delivery route? No. So then, the only alleged violation was that her front tire was over a faded yellow line? Dean shifted in his seat. It's still county property. Sheriff, are you aware that in the last 4 years, you've issued 53 citations for this exact offense? Yes. And that 47 of them were issued to black drivers? Objections flew. Wilkes shot up. Relevance, Your Honor, this is character assassination. Judge Reeve hesitated, then looked down at the motion Amira had filed the previous week. I'll allow it temporarily. But tread carefully, Ms. Caldwell. Amira nodded, then continued. Sheriff Dean, would you describe yourself as fair? Yes. Impartial? Yes. Do you recall ticketing a white councilman's wife last year for the same offense? Dean blinked. I chose to issue a warning in that case. But not for a nurse who had just worked a 12-hour shift and didn't see the faded paint? She was uncooperative. Amira raised an eyebrow. Do we have body cam footage of her being uncooperative? Dean looked down. No body cam was worn. Do we have dash cam footage? No. So we're just supposed to take your word for it. Wilkes objected again. Argumentative. Sustained, Judge Reeves said. Amira took a step back. No further questions. The courtroom stirred. For the first time, the jury looked unsettled. Not convinced, but curious. That was enough. Over the next 2 days, Amira called witnesses to paint a fuller picture of Danielle Brooks. First came Nurse Supervisor Karen Locke, who testified that Danielle had worked back-to-back shifts and had never received a single disciplinary mark in her 9 years. She's calm under pressure, Karen said. The kind of nurse you want in an emergency. Always respectful. Never late. She even volunteers at our mobile clinic once a month. Next came security footage from a nearby deli across the street from the courthouse. The defense team had hunted for days to get it, and it wasn't perfect, grainy, with a bad angle, but it clearly showed Danielle exiting the building and walking calmly to her car. No aggression. No confrontation. Amira played the clip frame by frame. No raised voice. No wild gestures. No evidence of hostility. Wilkes shifted uncomfortably. It's not audio. You can't tell tone. But you can tell intent, Amira replied. Then came a surprise. Amira called to the stand Lieutenant James Raleigh, a fellow officer under Sheriff Dean. He wasn't listed on the original witness roster.
That was the point. Lieutenant Raleigh, Amira began, were you aware of this incident on the day it happened?
Yes.
And did you have concerns about the nature of the arrest?
Raleigh paused.
I did.
A murmur rose from the benches.
And did you voice those concerns?
I told the sheriff I didn't think it was necessary to arrest her.
I suggested we just issue a warning.
He told me to mind my place.
Gasps. Wilkes objected, but the damage was done. Judge Reeve banged his gavel. Order. Amira stood confidently. No further questions. Outside the courtroom, things were changing. The crowd had doubled.
Protesters marched with signs bearing Danielle's face, and TV networks now had permanent camera setups on the courthouse lawn.
Interviews with legal experts aired daily.
Former prosecutors began publicly questioning the charges.
Even a retired state judge gave an op-ed titled, "This is what injustice looks like."
And yet, inside, Reeve remained unmoved.
He denied motion after motion. He refused to drop the felony obstruction charge. He kept jury breaks short and excluded a list of character witnesses Amira had submitted. But the pressure was growing.
Behind closed doors, courthouse staff whispered that the Georgia Judicial Oversight Committee had started making inquiries into Judge Reeve's courtroom conduct. Word was, someone had filed a formal complaint. On the fourth day of trial, Amira called Danielle to the stand.
Silence filled the courtroom as she approached.
Her voice cracked at first, but she steadied herself.
I didn't park there to break any rule. I didn't even see the sign. I had paperwork to drop off. I thought, 10 minutes wouldn't hurt anyone. I never raised my voice. I never resisted. I just got scared. I had never been in handcuffs before. My kids.
Her voice broke. Amira placed a hand on her shoulder.
You're okay. Danielle continued. I work hard. I've never been in trouble.
I didn't think anyone would believe me, until Ms. Caldwell showed up. She looked at the jury, eyes filled with tears.
I'm not a criminal. I'm a mother. I'm a nurse. I parked wrong. That's all. The morning of the fifth day felt heavier than the rest.
There was a chill in the air, even though summer still clung stubbornly to Georgia. Reporters stood outside in their windbreakers, clutching paper coffee cups and whispering updates into camera crews. Across the street, the protest had swelled to over 200 people. Someone had brought a small PA system and was reading off the names of people who had been overcharged or wrongly convicted in Macon Ridge County over the past 10 years. And inside courtroom 3B, something had shifted. It wasn't just the jury that noticed it. It was everyone, from the stenographer to the guard posted near the exit door. Something invisible, but unmistakable, the feeling that the tide was beginning to turn. Danielle sat quietly beside Amira, hands folded in her lap, shoulders straighter than they had been all week. She had become, whether she wanted to or not, a symbol. The face of a system pushed too far. And today, Amira was about to go further than anyone expected. Exposing the gavel. Amira's voice rang clear and direct as she stood up and said, Your Honor, the defense calls to the stand Ms. Kelly Dorsey, Judicial Clerk for the County Review Board. Wilkes immediately objected. Your Honor, this is a complete deviation from the witness list. Amira turned. We filed an amendment 2 days ago. The court clerk confirmed receipt. Judge Reeve's face tightened. She may proceed, but tread carefully, Ms. Caldwell. Kelly Dorsey was a small woman with horn-rimmed glasses and a leather-bound folder tucked against her chest like a shield. She took the stand, adjusted the microphone, and glanced nervously toward Reeve. Amira smiled softly. Ms. Dorsey, how long have you worked in the county clerk's office? 17 years. And your responsibilities include archiving legal records, correspondence, and judicial memos, correct? Yes. Amira took a beat. And in your role, you've handled formal and informal disciplinary reviews involving sitting judges? Yes.
Were you asked to assist in compiling documentation related to Judge Clayton Reeve in the past 5 years? Wilkes jumped to his feet. Objection, Your Honor, this is a violation of judicial privilege. I'm not asking about the content, Amira clarified. I'm asking if a review was conducted. The existence of an ethics review is a matter of public record. Reeve's knuckles whitened on the gavel. But he couldn't stop it. Dorsey nodded. Yes.
In 2022, there was an internal investigation into Judge Reeve's conduct regarding bond setting and sentencing disparities.
Murmurs exploded in the courtroom. Amira leaned forward. Can you describe the findings? Wilkes again, objection.
Reeve, this time, cleared his throat, his voice low and restrained.
Sustained. Ms. Caldwell, you may summarize findings only if they were made public by the review board. They were, Your Honor. I have the public statement entered into record as Exhibit G. She handed it to the bailiff.
The jurors read as the statement was projected onto a screen.
The board expresses concern over significant racial discrepancies in sentencing and pretrial decisions rendered by Judge Clayton Reeve.
While no official misconduct was proven at that time, the patterns identified warranted further monitoring. Amira turned to the jury. This is the man deciding whether my client deserves 10 years in prison. The courtroom was silent.
Reeve didn't meet her gaze. The breaking point. During the recess, news of the ethics review hit every major outlet. The headline on CNN. Georgia judge under scrutiny in high-profile parking arrest trial. Fox ran it as activists target judge over parking case, courtroom heats up. Social media exploded again. Protesters brought speakers and began looping Danielle's testimony outside. #ReeveResign hit over 1 million mentions by noon.
One protester, a retired teacher, held a sign reading,
"If the system is fair, why does it keep breaking in the same place?" Back inside, Amira struck again.
She called Dr. Hayden Rallis, a sociologist from Georgia State University, to the stand.
"Dr. Rallis," she said, "you've studied racial disparity in judicial sentencing for over 2 decades?" "Yes." "And in your analysis of Macon Ridge County, what did you discover?" Rallis pulled up a simple graph.
For misdemeanor offenses like parking violations or obstruction, black defendants in this county were 4 times more likely to be held without bail.
Sentencing averages also showed a 34% longer jail term. Wilkes tried to object, but the damage had been done. Amira let the silence hang, then addressed the jury. This case is not isolated. It's systemic. Danielle Brooks is not on trial. The system is. Pressure mounts.
Later that evening, Amira met with her team in a borrowed church hall just blocks from the courthouse.
Civil rights attorneys had flown in from Chicago and D.C., offering notes, strategy, and moral support. "Reeve's losing grip," one of them said. "This is now a political liability for the entire Georgia judiciary." "He won't step down," Amira replied. "But if we get enough outside pressure, we can force oversight. Maybe even an emergency ruling on sentencing authority." As they worked through the night, Amira received an email anonymously sent with a short audio file. It was grainy but clear enough.
A voice that sounded very much like Judge Reeves speaking to a colleague in private, saying, "She should have known better.
These people always push the rules.
They act surprised when it bites back."
The message ended there.
Amira stared at it for several minutes, then forwarded it to every major journalist she knew.
The next day,
court resumed with the tension of a taut wire. Judge Reeve walked in 30 minutes late, unheard of for his courtroom. His face was pale. He didn't speak for several seconds after sitting down. The bailiff handed him a folder. He flipped it open, sighed, and spoke with a voice 2 tones quieter than usual.
"It has come to this court's attention that new evidence has surfaced concerning potential misconduct.
At this time, the court is placing a temporary hold on all sentencing authority until review can be completed by the Judicial Ethics Commission."
Wilkes nearly dropped his pen.
Amira smiled for the first time in court. The jurors looked around at each other, eyes wide, whispers barely contained. The judge had essentially admitted he was no longer fully in charge of the outcome.
It was a silent admission of pressure, of weight, of scrutiny. And Danielle?
For the first time, she sat taller.
She wasn't just a defendant anymore.
She was a mirror being held up to the entire courthouse. The courtroom was at capacity.
Every seat in the gallery was taken. Reporters filled the back rows, their laptops open, fingers ready.
The courtroom sketch artist had already started her outline of Danielle at the defendant's table, hands clasped, lips barely moving, eyes locked forward.
Outside, the crowd was larger than ever.
A growing sea of signs and cell phones.
News vans from every major outlet lined the street. The local sheriff's department had to call in state patrol to redirect traffic.
And above it all, on the steps of the courthouse, stood a group of nurses in uniform, holding up a massive handmade sign.
She saved lives. Now let her live hers.
Inside, the jury had been deliberating for just over 6 hours. Amira sat still, not fidgeting, not blinking too much, her posture calm but coiled.
Wilkes sat like a man on the edge of a long fall.
And Judge Reeve, his authority now publicly cracked, kept glancing toward the hallway doors as if expecting someone to burst in with more bad news.
Then came the knock. The bailiff opened the jury door. A folded piece of paper was passed to the judge. He read it. Have the defendant rise. Danielle stood.
Her knees trembled slightly, but Amira placed a hand on her back, anchoring her. The judge handed the note to the clerk. In the matter of the state of Georgia versus Danielle Brooks on the charge of felony obstruction of justice.
A silence fell like a curtain.
We, the jury, find the defendant not guilty.
The silence exploded into noise. Gasps. A sob from someone in the gallery.
Outside, a cheer broke through the courthouse windows like wind.
Reeve banged his gavel furiously.
This court is not yet adjourned.
But no one was listening. The clerk read again.
On the charge of unlawful use of a government parking space, we find the defendant guilty, with recommendation for civil penalty only.
A murmur, but no outrage. $100 fine. Nothing more. Danielle sat down.
Her hands shook, but her face broke into a single, slow smile.
Amira's hand didn't move.
It stayed there on her shoulder, steady and proud. The judge cleared his throat.
I will issue sentencing on the remaining infraction. But the bailiff interrupted.
Your Honor, message from the Judicial Ethics Commission.
A sealed envelope was passed to Reeve. He opened it. Paused.
His lips thinned. This court is now adjourned. And with that, he stood and left the bench, the first time in his 28-year career that he didn't finish a proceeding himself.
The fallout.
Outside, Danielle was swallowed by a wave of hugs. Her kids ran to her, Malachi and Zoe, nearly knocking her over. Reporters shouted questions, but no one got answers.
Not yet.
She just smiled and held her children close, whispering over and over again, "It's over.
It's finally over."
Amira stood back, giving her space. A journalist from the New York Times approached.
Ms. Caldwell, do you think this case will change anything?
Amira looked past him, toward the courthouse.
Change doesn't happen in a courtroom.
But it can start there.
The news cycle was merciless. That evening, CNN aired a segment titled, Justice or PR Move? Inside the Reeve resignation rumors.
Because yes, by midnight, the rumor mill had roared to life. Judge Clayton Reeve was under emergency review, facing possible suspension and even removal from the bench. Civil rights attorneys submitted formal complaints by the dozen. A federal judge agreed to review audio footage leaked anonymously that week. Then the real shock dropped. A whistleblower from inside the county prosecutor's office revealed that Wilkes had met privately with Reeve before the trial began, an ethics violation that could cost both men their careers. The meeting was logged by a courthouse security camera.
Though no audio existed, the date and time were damning. By the next morning, both men were trending on Twitter. Danielle's voice.
2 weeks later, Danielle stood in front of the same courthouse, but this time, behind the mic.
She was flanked by Amira and 24 supporters.
A soft wind blew as she read from a folded piece of paper.
I stood in this courthouse as a criminal. But I leave it as a citizen. A mother. A nurse. I didn't want to become a symbol. I just wanted to go home that day.
But sometimes, the world picks you.
And now that it has, I'm not going anywhere.
She paused, breathing through the lump in her throat. This case wasn't about a parking space. It was about the space we take up in this country. The space we're allowed to exist without fear. The space to be heard.
Today, I took that space back. The crowd applauded. Danielle stepped down, tears streaming, but proud. She hugged Amira. Long, deep.
"Thank you," she whispered. "You don't owe me thanks," Amira replied.
You held the line.
I just held it with you.
Behind the curtain.
In the days that followed, more details emerged. Judge Reeve was officially suspended pending ethics investigation.
Legal historians began pulling records of his past cases, and what they found wasn't pretty.
Patterns of oversentencing, disproportionate punishments, suspicious private meetings.
The DOJ opened a formal review. District Attorney Wilkes?
He stepped down before the bar could remove him. An interim DA took over and immediately launched a review of dozens of minor cases, many of which were dismissed or converted to civil penalties. Several wrongfully convicted citizens filed for expungements. The county had changed, not overnight, but visibly.
Amira's choice. The offers poured in. TV deals. Book agents. Interviews on national shows. One law school even offered Amira a full-time teaching role. She took none of them.
Instead, she used her growing influence to launch a new nonprofit, Equal Bench, dedicated to monitoring judicial behavior in rural courtrooms and offering legal support to people caught in similar traps.
Her first client? A 17-year-old boy arrested for loitering near a city building after dropping off his grandmother's groceries. A final visit.
Months later, Amira visited Danielle again, this time at the hospital where she worked. They sat outside on a break bench as the sun dipped below the trees. "You know," Danielle said, "I still can't believe they were going to lock me up for a parking mistake."
Amira nodded.
That's how systems work when no one looks at them.
Quiet. But cruel. Danielle looked off into the distance. But not anymore.
They sat in silence for a moment, just breathing. Just existing in the space they'd reclaimed.
2 months had passed since Danielle Brooks walked free.
The fall breeze had returned to Macon Ridge, tugging yellow leaves across the courthouse steps. The same place that once held protests now held silence, but it wasn't the silence of suppression. It was the silence of transition, of something finally shifting. The old stone courthouse, once seen as untouchable, now had cracks, literal and metaphorical. Inside, room 3B had remained closed since Judge Reeves' suspension. The courtroom lights were off. The seal above the bench still bore his name, though rumors said it would be removed soon.
Some said it should be left as a reminder of what unchecked power can become.
Others said it should be sandblasted off and buried. But the truth was, it didn't matter. What mattered now was what came next. The trial of a judge. Judge Clayton Reeves sat, not at the bench, but at the defense table.
For once, he wore no robe. Just a gray suit, one that didn't quite fit him anymore.
The weight loss from stress had sharpened his jaw, hollowed his eyes.
He looked like a man aged a decade in weeks.
The Judicial Ethics Commission had finished their investigation.
The charges were clear. Abuse of authority. Willful misconduct. Racial bias in sentencing. Unreported private meetings with prosecutors.
He was offered a deal: resign voluntarily, surrender his license, and avoid public hearings. But Reeve refused. He still believed he could win. And so, the hearing was held in the same building where he had once ruled with impunity. This time, Amira sat in the front row of the audience.
Danielle was beside her. The judge presiding over Reeves' ethics trial was federal, sharp, and unimpressed.
One by one, witnesses took the stand, former clerks, defense attorneys, even courthouse staff.
Each testimony painted the same picture, one of arrogance, favoritism, and a decades-long pattern of punishing certain people more harshly than others. Amira never looked away from Reeves as he sat there, still holding on to denial. And finally, the ruling came. In light of the overwhelming pattern of judicial bias and ethical violations, the Commission recommends permanent disbarment and full removal from the Georgia bar. Furthermore, all prior cases ruled under Judge Reeves' jurisdiction within the last 10 years are to be reviewed. No gavel slammed. No applause. Just a simple, irreversible end.
Clayton Reeves stood up, looked around the courtroom where he once commanded fear, and found none.
No respect. No loyalty. Only justice. Danielle's journey forward.
After the trial, Danielle returned to nursing full-time. But something had changed in her, and everyone around her saw it. Patients stopped her in the hallway.
"You're the one who stood up," they'd say. "You didn't back down." She'd smile, sometimes laugh awkwardly. She hadn't asked for the spotlight. But she also didn't shy away from it anymore.
She was invited to speak at high schools, at churches, at local colleges. Her message was always the same.
You don't need to be perfect to deserve respect. You don't need to be rich to deserve fairness. You just need to not be quiet.
One night, her son Malachi asked her, "Mom, does that judge hate people like us?"
Danielle hesitated.
"I don't know if he hated us," she said gently.
"But he didn't see us. And when people don't see you, they stop caring what happens to you." Malachi thought about that. Can people see us now?
Danielle looked into his eyes, so full of questions, so wide open to the world.
"Yes, baby," she said. "They see us now." Amira's legacy.
Amira Caldwell had always been a fighter, but the Danielle Brooks case had changed her too.
Her nonprofit, Equal Bench, was now operating in 4 counties.
They had 3 staff attorneys, a network of volunteers, and a hotline that received over 200 calls a week.
She didn't chase cameras, didn't give interviews unless she had to. Her mission wasn't visibility. It was accountability.
Still, every now and then, she allowed herself a moment of reflection. She'd sit in her small office, surrounded by stacks of case files and newspaper clippings, and stare at a single photo pinned to her wall, Danielle standing with her children outside the courthouse, smiling, free. That photo reminded her why the fight mattered.
Not just for one woman,
but for the thousands like her.
A county reborn.
In the year that followed, Macon Ridge saw more change than it had in a decade.
3 new judges were appointed, each vetted through a community advisory panel. A civilian review board was created to oversee judicial conduct and prosecutorial fairness.
The DA's office implemented new training on bias and sentencing standards.
Misdemeanor cases dropped by 37%. Civil citations increased, jail time decreased. And perhaps most importantly, people began to show up. To vote. To speak. To witness. Danielle was asked to cut the ribbon on a new courthouse annex dedicated to public legal resources.
When she stepped to the microphone, she kept it short.
"This building is here because we didn't stay silent. The law belongs to all of us. Make sure it hears your voice." Final words.
This story began with a parking mistake. But it ended with a movement.
Because real justice isn't about dramatic courtroom moments or last-minute verdicts. It's about what we tolerate. What we question. What we're willing to change. Danielle Brooks didn't want to be a hero. She just wanted to go home.
But her courage forced a broken system to face itself and forced a community to rise. So the next time someone tells you a story like this doesn't matter, that it's just a small case, a minor infraction, remember Danielle. Remember her children waiting outside that courthouse. And remember that sometimes, the smallest crack in the pavement can split open the whole road.